komna á þennan blaðamannafund sem haldið til það að niðurstöðu dómsins í Icesave málinu. Við byrjum að því að Jón Lóik fer yfir forsendur dómsins og síðan tökur bæði hann og tegniði í sýknudóms. Please, Thank
you very much. I'll just very briefly summarise the main findings in the judgment. The case against Iceland was in two parts. The first was concerned with the Deposit Guarantee Directive, and the second was concerned with discrimination. On the Deposit Guarantee Directive, Iceland accepted it had to set up a deposit guarantee scheme, the TIF, but the issue was whether if the TIF could not pay depositors, did the Icelandic state have to ensure that the depositors receive their money? And on that issue, Iceland has been successful, and the court has ruled that there is no requirement for the state to ensure that depositors are paid. Iceland was also successful on the second issue, discrimination, and the argument there by the EFTA Surveillance Authority was that because Iceland had moved Icelandic accounts in Landsbanki to the new Landsbanki, that it discriminated against the foreign depositors because it had not paid out under the deposit guarantee scheme. And there, Iceland's argument was really that these were just two very different things, and that the Icelandic branches were essential to the Icelandic economy. And the court essentially accepted that and said that it wasn't discrimination to treat those two types of depositors in a different way. And that, in very, very short summary, is what the court said over about 240 paragraphs. So if anyone has questions, we're all here to try and answer them.
I have a question here. It says in the ruling that the court has already held that directly in light of Article 4 is deals with discrimination. It poses no obligation on the defendant, that is Iceland, to ensure that payments are made in accordance with the requirements of the directive to Iceland depositors. It's a direct quote. I want to ask you, given the fact that many lawyers believe that there was some sort of state responsibility to ensure those payments.
Yes.
Was Directive 94/19, wasn't the directive in itself flawed?
Well, that is definitely an argument. The court said, rightly, that the directive did not deal with what should happen where a deposit guarantee scheme is unable to pay. And I think that's part of its thinking. It said, well, since then the directive has been improved and there have been extra steps in banking regulation, but we're only concerned with the directive as it applied in 2008 and 2009, when Iceland was bound by the directive, as it was at the time. So it's right that the directive does not provide an explanation for what should happen if the guarantee scheme does run out of money.
So how do the lawyers in Brussels, how can they come to the conclusion that there was some sort of legal responsibility on Iceland to ensure payments to depositors? How can they come to that specific conclusion if the directive itself is clear?
Well, it was a matter of interpretation of the directive, and they put up detailed arguments, but those arguments were not accepted.
Can I start a question to you, Mr. Lord?
Please.
Regarding, it's a little bit another issue perhaps, but in the continuation of this, do you think there's a ground for Iceland to perhaps sue the British, Dutch, and the European Union even, on some grounds in the wake of this?
I'm afraid I really don't know. I've been here helping with the Icesave case, and I think I'd have to invite my colleagues to answer that question.
Dómur hann í sjálfu sér, kannski veitir enga leiðsögn af því, hvort það sé einhverjar kröfur sem að Ísland ávegna þessa máli, eða hvort það eitthvað sjóður sem að vera að sækja sérstaklega þessu máli, það sem ég ætti að vera á.
Það ekki styrkt á einhvern máli, kannski ef það farið ekki loku skoti fyrir þetta.
Það var sem fyrirfélag þessu. Það ekki beint samkvæmt það við. Það sjálfstætt mál.
Did the former negotiations between the delegates from Iceland and the British and Dutch have any influence on the result of the court today?
Well, it's interesting because they were discussed quite a lot by the parties, and the British and the Dutch made a lot out of this issue in their pleadings to the court, but they're not mentioned at all in the court judgment. Now, whether it was influential anyway, I can't say, but it literally was ignored in the ruling of the court itself.
There has been some discussion about the possible legal impact of this ruling regarding the question of deposit insurance in the European Union.
Yes.
You said earlier today that you wanted to give us a time to read the verdict and maybe analyze this further on a later stage. Are you willing to give us an opinion on that sense? Do you think that this ruling will have a significant impact on the discussion of the future of these things in Europe? Or?
Well, my personal opinion is that it will. Of course, it's the binding word of the EFTA court, which is the final court in Iceland, Norway, and Liechtenstein in matters of EEA law, but it's also highly influential in EU law. And you saw that the European Commission thought this case was important enough to come and intervene. They didn't regard it as a purely Icelandic issue, and I'm sure that in Brussels they will study the judgment very carefully. And it's obviously a matter of speculation what they will make of it. But the answer is yes, I think it is important in the EU.
Was there anything in the ruling today that was a surprise to you?
Well, we're just delighted by it.
How significant was the fact that the applicant never questioned the fact it was not possible to extend the rescue to overseas branches of Landsbanki when you were dealing with Article 4?
Well, it was obviously important in the argument and in the conclusions of the court, but the court does say that even if the surveillance authority has put its discrimination plea differently, the court suggests there were reasons why it might have found the difference in treatment was justified. It talks about the margin of discretion in making fundamental choices of economic policy. Now, it doesn't have to rule on that because, of course, given the way the surveillance authority argued this case, it only had to deal with the argument in front of it. But the suggestion there is that maybe the result would have been the same, even if they hadn't taken that position.
If I may, the cost of Iceland expenses because of all this trial, as I understand, that will not, that will be paid by, Iceland will not have to pay for that. That's
well,
understand correctly.
There is a ruling.
They don't mention any amount. In
no. There is a ruling in the judgment that says the EFTA surveillance authority will pay the costs incurred by Iceland. But again, I defer to my colleagues about what that means in practice.
What is the